Good morning, Kesrin.
Morning, sir.
So it looks like we're a little short-handed today, as per usual. Um, this is a small tutorial, so I never expect much. Um, so I will give you the option if you want. If this is the time that works for you, you are more than welcome. We can continue. We can have this conversation for however long it goes, and then you can be done for the week. Or if you'd like to attend another tutorial and get, well, never mind. We have another student, so we'll carry on. So, well, I say that assuming that she's actually able to join. Um, so assuming that she joins in the next couple of minutes, we'll get this rolling. Otherwise, you can decide whether you want to do this now with me or whether you want to come to another tutorial and do this with a different student. Because the way that this is going to be structured is you're going to present what you're going to discuss what you've prepared with a partner, and then the two of you are going to present each other's work to the class. So if it's just you and me, then you're going to be talking about your preparation. I'm going to sort of poke at it a little bit, and then we're going to call it a day. But so I'll leave that up to you. Which one would you prefer?
If you don't mind that, sir, honestly, I honestly prefer the small tutorial.
Okay. Okay. So you want to do this now? Okay. So
Okay, there's a student here.
yes. So the way that we're going to structure this is what's called a think, pair, share. Okay. Now, so you were given the question on e-learning. Let me pull it up just to have it handy for you. Here. So put it in the chat for you. So this is the question that you're being asked with. Write a fact pattern that, if true, would give rise to an inference of res ipsa loquitur. This fact pattern should not match any case that you have read, either in this course or elsewhere. The point of this exercise is to think about what sorts of events are impossible in the absence of negligence. So the think, if we were doing this in sort of a normal classroom situation, you would take a couple of minutes to think and maybe write some things down. Hopefully you have already done that piece of this, as you were sort of asked to, prep this before you came. The next step is the pair. So that's going to be, you guys go off into a breakout room and present to each other what you came up with. Okay. And you're basically trying to explain it to each other, and then you come back, and Kesrin, you'll present to me Elan's scenario, and vice versa. Make sense? We clear on what's happening?
Yes, sir.
Okay. Then I'm gonna put you into the breakout room, and that's just to give you a space that I'm not in, so that you can have about 10 minutes to discuss this and get your mind straight on what each other has, and then you'll come back and talk to me. Okay? So. And there you go. We are back on the record. So I hope that this exercise sort of helps to make sense for you guys. Let me start by asking, do you feel like you understand what your fellow students were presenting to you?
Yes, sir.
Yes, sir.
Okay, great. So then let's get started. Kezran, can you explain to me either Ilan or Rosalind's proposed theory of res ipsa?
Okay, yes, sir. So for Ilan, basically,
Are you saying anything, Kezran? Because I'm not hearing anything.
I can go first.
Okay, go ahead. Go ahead. While Kezran sorts out his tech issues and hopefully comes back in. So.
How did you want it done? Just read their fact pattern and then kind of.
So yeah, why don't you start by explaining the facts as they presented them, and then explain why you think res ipsa should apply. And I'll see if I can ask some questions that maybe if there's anything that's missing, anything that needs to be fleshed out, or possibly if you've just anticipated everything, I'll just go, great, that's right. So.
Oh. Okay, cool. So the facts are John Doe works at a supermarket, and while on his lunch break, he was eating in his car. When he went to go back, he was sitting in his car in the parking lot of the supermarket, which is opposite a body workshop.
Can I ask very quickly whose fact pattern this is?
Yeah, sorry, this is Kezran's.
Okay, go ahead. Continue.
Sorry about that. As he was leaving his car to go back to his job, there was an explosion at the body shop, and pieces of metal traveled through the air and landed on his face. He was then taken to the hospital to undergo surgery. This is a case of res ipsa loquitur, in that the defendant had exclusive control of the situation. So the body shop, the explosion happened on their end. It was metal from the body shop itself, and the party was injured. The injury would not have occurred except for the negligence of the body shop. So the injury wouldn't have occurred had the explosion not occurred, for whatever reason the explosion occurred. And it was definitely not because of John Doe, who is the plaintiff, that he received injuries. So he didn't contribute in any way.
Well, here's the thing that I'm concerned about, right? Res ipsa is really about the issue where it is impossible for this to happen absent the negligence of the person in control.
Okay.
And, you know, I can tell myself a story where someone else's negligence results in the explosion, right? Suppose that somebody comes careening around the corner in their car and they drive into a non-negligently stored explosive canister of explosive material, right? And that causes the explosion. The body shop hasn't done anything wrong. They stored the canister appropriately. They sort of protected it from reasonably foreseeable dangers. And this person came along and their negligence caused the explosion. So I think this is a really creative and interesting example. And I certainly, sympathize with poor John Doe. But one of the, and I think one of the things that it's really useful to illustrate is how, in order to prove res ipsa, you have to demonstrate that there's no explanation other than the defendant's negligence, right? There's no possible explanation other than the defendant's negligence. So, right, if the story said explicitly that, there was no traffic nearby, there's nothing happening at the body shop, then you might have something that would give rise to an inference, right? But do you see how proving res ipsa requires you to put on that additional evidence? Does it make sense what I'm saying?
Yes.
Okay.
Yes, sir, definitely.
Great. So Rosalind, Kezran, I will let you guys sort of decide who goes next, because the person who goes last is stuck with whatever's left in terms of which scenario they get to explain. So I will let you guys sort of duke it out amongst yourselves.
Okay, mainly, sir, this is the first tutorial for me.
Okay.
That bit you just said, can you repeat that?
I'm a little confused. The first thing that I'm confused about is where have you been all semester? But that's a conversation that we can have. We're not going to have that
I've been
conversation
in your
now.
lectures. I've been in your lectures, but I
We're-
didn't get into the tutorials.
Yeah.
It was trying for a long time. Okay, go ahead.
The other thing is I'm asking you to explain something that the fact pattern that your fellow students offered up in the breakout room. So you were late, so you may not have, and it was technical issues, and it's fine. So you may not know what they put together. So this is why I'm asking who wants to go next.
I'll go, sir.
Okay. So Kezran, take it away.
Yeah, so basically, so there's a store, and the store is essentially
And
restocking.
whose fact pattern is this?
Elan.
Okay.
Yeah, so there's a store, and they are now restocking for the next day. So the employees restock. Tori is excited about the new stock in the store. So Tori goes in the next day and she spots something that she likes. It was a cushion, right? So Tori goes near to the shelf. The shelf Tori had not touched anything and the shelf falls. Tori moves out of the way and a box cutter which had been left in the open sliced to her hand. It was no fault of Tori that the shelf fell.
Mhm.
It was the duty of the store to ensure that the shelf, because remember, Tori had not touched the shelf, that the shelf was placed properly, that the box cutter was not out in the open. And so it would be a case of res ispa locator, simply because Tori had no say in the matter and it was within all control of the store.
Yeah. And the second piece of this is, what explanations can we come up with that would not be the store's negligence, right? And I think that you've done a good job of sort of closing a lot of those doors. The only, if I were the store's attorney, right, the only thing that I might come up with would be to ask if there were any third parties around, right? If another shopper had smacked their trolley into the shelf, then that might knock the shelf over without it being the fault of the shop. Now, you as Tori's attorney may respond, regardless of how the shelf fell, if the box cutter hadn't been left out and open, there would have been no harm to Tori, and the box cutter was completely under the control of the store, right? So this becomes a situation where there is an argument that the defendant can make, but it's not entirely, there's an answer, and so the court is sort of left weighing who's responsible, right? So as the plaintiff's attorney, you could close that door by establishing that there were no other shoppers in the vicinity, and so the shelf just sort of fell on its own. But you still have the possibility of winning if the court agrees with you that the box cutter itself was the instrument of harm and it was under the defendant's control entirely.
Okay, cool. I do have a question. Can I also win the case? Because literally it was, the main thing was that, it was the store received new stock. So a team of people fixed the store. So the shelf itself was not put in properly. So that was also the problem from the store, that the shelf wasn't. So when Tori went in front of the shelf, because it wasn't, or does that
well, I think I think certainly that establishes an element of control, right? The issue would be, as the plaintiff's attorney, how would you know that or prove it? And so, the shelf falling over doesn't just happen because it was improperly installed, and res ipsa only applies where you don't know the reason why the event happened, but the only possible explanations all include the defendant's negligence. So does that make sense?
No, that makes a lot of sense. The
Okay.
fact that I should have known as well. Okay.
Yeah. So I think, I think that's perfectly reasonable as sort of like the actual cause. But when you sort of lower the veil of ignorance and ask what would the plaintiff know, then you have to ask, well, how would the plaintiff know that the shelf was installed incorrectly, right? Okay, Rosalind.
Okay.
I get that
I'm ready.
that
Can you
you're
hear
sort
me?
of yes, I get that you're sort of late to the party. So if you don't have anything prepared, that's okay. We can sort of wrap
I'll
this up.
try.
But if you have
I'll
something,
try.
I'd love to hear it.
Okay, I have an example here. Eleanor walks her dog several blocks to the park every afternoon, around the park every afternoon, around 4 p.m. on Tuesdays. Eleanor's dog was passing by the neighbor's house, and his dog charged at Eleanor's dog. Another neighbor helped the dog to help the neighbor's tried to take the dog off of Eleanor's dog, but her dog was seriously injured, and Eleanor was bitten twice as well.
Yeah. So I like this because it does a couple of things. The first one is, you know, in a lot of jurisdictions, unless a dog is what's called an inherently dangerous breed, and what those are sort of varies from place to place. But unless a dog is one of these breeds, the dog is entitled under the law to sort of one free bite.
What?
Like I'm very serious about this. Like I'm chuckling, but this is actually serious doctrine that the first time the dog bites somebody, the owner will not be held liable because the owner could not have known that the dog had a propensity to bite. Once the dog has bitten somebody, the owner's liable for any subsequent bites because they should have known that this was something that the dog did. So that would be one fact that if I were the dog's owner's lawyer, I would be asking, has this happened before, right? And if it hasn't, then I would be arguing that there's no negligence here because the owner couldn't have known to have kept the dog away. But that, you know, that's a unique wrinkle of dog bite cases. The other issue that I see as the dog's owner's lawyer would be to say, well, look, you know, we did, you know, we put up a fence, we kept the dog in the yard, you know, we don't let the dog out without a leash. The dog dug under the fence and got out. And that would raise the question, and I think it's a question for the fact finder, for the court, right? Did the owner have a responsibility not just to sort of fence in the dog, but make sure that the dog can't dig their way out, right? And that's a close question. So I think that this is giving us, you know, some movement towards res ipsa, but if I really wanted to prove res ipsa as the plaintiff's lawyer, I would definitely want to establish that this wasn't the first time that this dog had attacked somebody. And I would also want to establish that the owner had not, that there was no way for the owner to have taken reasonable steps to keep the dog away from potential victims. So, but I think, I one of the things that I really like about this exercise is I really like hearing the creative fact patterns that students come up with. And B, I think that it illustrates very clearly for you guys how difficult it is to prove causation in these odd circumstances, right? Where you can't figure out what actually happened. Like that's a relatively narrow slice of cases that we're working with. Okay. So what questions do you guys have about this exercise or anything else? And I'm happy to answer.
So you said that that's like a relatively small amount of cases
Mhm.
for this principle. Like, but like, are they like specific cases for certain things, or would any case to show the doctrine work?
So the answer to your question is that you when you are evaluating, right? So the way that I sort of think about this is I want to prepare you guys to do a client interview and be able to discern the issues that are in the case. And so you should always be looking for, is this a res ipsa case? But you should recognize that it's actually quite difficult to fit into the res ipsa box, right? So very few cases actually will fall into that category. But you should always be looking to see if it's a possibility. So does that answer your question?
Yes, sir, it does. It does.
Okay. And I should note, right, Professor Cotolini makes the point that with res ipsa in particular, the cases don't really give us much in the way of principles. It's the case law on res ipsa appears to be basically just like a series of examples of, this is a situation where res ipsa happens, you know, where we can draw the inference. But it's hard to discern something that gives us like a test for res ipsa that's any more clear than what we have, which is the control over the instrument of harm and no explanation other than negligence. So, okay. What other questions do you guys have? Nothing?
Not right now.
Okay. Okay. Well, then I'm going to let you guys go just a couple minutes early. I really appreciate you guys being engaged and enthusiastic. And we will see you guys tomorrow. I sent an email about what we're going to cover tomorrow, so please check your email. And yeah, take care and bye.
Okay, thanks, sir.